Good morning. Had a little bit of technical difficulty there for a second. Sorry about that. This is Travis Copenaver.
Nicholas Galendez.
This is Cannabis Live. We're here this morning to talk about a certain topic for primarily medical marijuana applications and how caregivers on those applications are going to expect some follow-up with LARA and the Bureau of Medical Marijuana as those materials are going to get reviewed in primarily the background check portion materials. We're going to get to that in a moment. To start our show, we do want to announce Cannabis Legal Group is planning a conference for medical marijuana in October. We're currently designing the agenda for that. It's going to be October 11th, which is a Thursday, and we're anticipating like an all-day event to go over kind of the status of the medical marijuana application process at that time, and also obviously anticipation of the November vote for recreational marijuana. I'll have a lot more information about that soon, but be watching for it and save the date. It will be October 11th.
Cobo Hall.
Cobo Hall. So we'll have as much information about that as we can get it. But Nick, let's dive right down into our topic today. Basically, why are we talking about this?
So during the MMFLA application process, step one, pre-qualification. There's a lot of disclosures involving your criminal history, any civil litigation, tax history, tax compliance, bankruptcy, government regulation. Basically, you provide the regulators with the full picture of your past. And in connection with that process, we found out that, along with those initial disclosures of 3 years of tax information, all of your bank statements you're connected to, and thinking about it objectively is that, you give them all these documents and there's a bunch of money and there's a bunch of businesses and, they want you to put more into context for them. And that requires some follow-up questions. And they're asking these questions of every applicant, not just caregivers, but what we really wanted to focus on was the questions that do have more of an impact on caregiver conduct in the past.
Right. So like Nick says, any applicant or supplemental applicant in this process is going to have to explain information provided. So if you're providing your tax returns and bank statements, LARA has the ability to ask questions to kind of understand the context of those documents, the context of that information provided. But since we're a cannabis law firm and we want to talk about a cannabis topic, clearly a topic, and as you'll see, of very great interest is, well, what if you're a cannabis person, like if you're a caregiver or a patient, what specifically is LARA following up regarding that conduct or that history when it's being presented in your materials? Mm-hmm. So before we get to what the actual questions we're looking at are and our thoughts on them and things, what about the law lets the administration here ask these types of questions?
Mm-hmm. Well, yes, it's definitely to be expected. I mean, I think all applicants going into it, that was the bare minimum on the disclosures, those bank statements, it's not a typical thing to give someone all of that tax and financial information for no reason. I mean, we understand this is going to be a new, highly regulated, compliant industry. Michigan has very stringent disclosure requirements. And so that's actually built into the state law. It allows the board and the department to gather all this information, as we just mentioned. But it also kind of says, they're allowed to, look for history of noncompliance. They're allowed to ask for any other documents, disclosures created or requested by the department that aren't inconsistent with the Medical Marijuana Facility Licensing Act or the actual emergency rules. So to say that, okay, they're asking questions of applicants' financials and bank statements, that's consistent with what the disclosures require in state law. So it's not unprecedented, it's not unexpected, but it's definitely questions that need to be carefully looked over, carefully answered, carefully thought about in the application process for everyone.
Right, and LARA's been asking these types of questions basically since the beginning, since the first applications, but they're now starting, at least from the applications we're working on and seeing, starting to become a little more standardized. And we like to just show you what they look like and what you're expected to do when you're getting prompted like this. Mm-hmm. So while we talk about this, I'm going to jump over to our desktop here. Give me a second. I'll make sure I can get this working. Let's see. Of course, it's not where I left it. There we go. Mm-hmm. So this is an example of the types of questions you're going to be expected to see. And effectively, it's going to start out with some pretty basic stuff. But and this doesn't necessarily have to be for cannabis. You'll get questions like this for whatever your history is prompting LARA to ask about.
And this is consistent, too, with the disclosures. There's a disclosure 2D, 2D SA for supplemental applicants, and 2E and 2E SA. And what 2D asks is about your other marijuana business interests. So this is kind of asking, whether or not it's related to the marijuana industry. Perhaps in this section, you provide a little bit more information if you're an operator in other states.
Blank screen? Okay.
In Disclosure 2E.
Yeah, sorry. So if that's not popping up, we'll read them out. We have what we see might not be what's getting presented. So we'll keep it on us mostly. Thanks for letting us know that. But effectively, the question starts with, and the example we're going to show is what's called a base question. It's a standardized set of questions LARA is sending out. The question starts with, provide a comprehensive overview of every business interest, whether or not the business is related to the marijuana industry. Include the following information for each business. The first couple things are pretty straightforward. The name of the business, the type of business entity, so that's going to be your LLC, your corporation, or if it's a sole proprietorship or something like that.
And just to stop you for a second, too, those two questions are already on the disclosures, more or less. You've identified the name, the address, the federal tax ID number, and your percentage interest in it. So those are already kind of duplicative, but they kind of lead into the next questions as they continue to go along.
Right. And it's the next couple, so it sounds like some can see, some can't. The next couple questions are where they're trying to learn more about those businesses. It's not always going to be immediately apparent what your different businesses are just based on name alone. And even if you say it's a marijuana business, they're going to want to know more about it. So the first question is something that's kind of topical given the last couple board meetings. The type of business conducted. And they specifically in this set of questions, and these questions aren't necessarily standardized to the point where everyone's going to see these exact questions. But this set of questions says, if a consulting business, describe the services provided and whether the services are provided via a contract or other arrangement.
Yeah, and so about consulting, is there anything particularly, wrong about consultants, or why do you think that they're asking this? Just kind of pitch that question to you.
Right. So, talking about and again, this isn't necessarily marijuana specific, but a lot of applicants have marijuana history. So the reason they would be asking is if you're a consultant or you're providing a service and you're being paid for it, a lot of times there's a lot of reasons LARA is going to need to know that. There might be something in your bank statements that needs clarification. If you're getting large payments on a regular basis, or if you're getting paid in cash and you're making cash deposits in a bank account, and they're at a requisite payment level that LARA wants to make sure those are legitimate payments, explaining to them what this business is doing, how it's connected to you, if it's an LLC with its own bank account, or was it a sole proprietorship where you're getting paid as an individual, they're going to want to help get some context to the information you're providing to them. So being a consultant in and of itself is not a problem. And arguably being a consultant for the cannabis industry that has viable, legitimate purposes too. But, what LARA wants to know is, if you're a caregiver and you're making, you're a consultant in some capacity to the marijuana industry, what kind of consulting were you doing? How much were you being paid for it? If you're getting paid egregious amounts for something that, the market wouldn't warrant such payment, they're going to have problems with that. If your history, if your relationship to whoever you're providing those services to, is reasonable given what you were doing, that might not be looked at as hard. So, if I'm helping Nick for an hour and I get paid a couple $100, it's going to look a lot different than if I'm helping Nick one time and I get paid a couple $1 million. Now, obviously, I don't expect that to be the case all the time. But, that's just an example of, when this information will be mattering more or less.
And I think this is helping the department connect the dots. As I mentioned, they're asking for your W-2s and 1099s. They ask for your tax returns. They ask for your bank statements. So even without these questions, they could see, okay, well, here's how much this person makes on their 1099, and here's what their employer paid them on their W-2. Here's what bank accounts have consistent deposits. Here's where money's coming from and going. And you fill out all of the application disclosures and information. One of the affidavits and attestations makes you do it under penalty of perjury. And so, we've always said this application process is a test. You sign off a lot of information anyway that they have. And I think they want you to present it to them thoroughly, completely, honestly. And this is just one of them. I think if you truly were a caregiver and had knowledge and were helping other caregivers with their growing techniques, lighting, any soil and pH issues, things like that as a consultant, then that's correct and truthful to disclose. It's just the question of, if you were a caregiver and you put the consultant hat on just as a reason to kind of put that down there to maybe have income that was questionable,
or to explain other income that might be questionable. That's what they're looking for. Let's look at some of the questions following up that then. So how was the income received? Were you making it via salary? Were you getting were you drawing it from some location? Was it one-off payments? And then related to that is, okay, now that you've described what this business is, what kind of business it was conducting, and how LARA can expect to see the payments coming in, how is that business associated to the actual applicant for the cannabis business? So if you recall, when you submit your licensing application to LARA, there's the EIPP, that would be the actual business seeking the cannabis license, which would make all the same disclosures as everyone who we consider a supplemental applicant. And just to remind anyone who might be watching, not as familiar with the process, you kind of explain to us what supplemental applicants are.
Oh yeah, so each person within that entity, whether it's an LLC or a corporation, will have some kind of interest in it, membership, stock holding, a number of stocks. There'll be an officer, a director. So each one of those individuals that has control or decision-making authority within the actual entity, if they're a manager of the LLC, if they're managerial employees, all of those people are considered supplemental applicants of the actual entity.
Mm-hmm. And the questions that the actual company itself needs to answer and supplemental applicants have to answer are basically the same. But, that particular line of questioning we just went over, as Nick mentioned, is for where you're listing what is called other interest, or basically your capacity with certain businesses, what your relationships to those businesses are, if any of them warrant, additional information. And obviously a cannabis-related business is going to be something the state's going to need to look at a little more closely than a, unrelated industry business. Mm-hmm. So like we said, though, we're talking about caregivers. So, not all caregivers are necessarily going to have a business that they've been running for their conduct. A lot of them are just going to be acting as caregivers. So the next question we're going to talk about is doing just that. And I'll let Nick kind of explain it to us as we go here.
Okay, so question number 2 starts off as, provide us following information regarding any marijuana associations. And it just asks, plainly, are you a medical marijuana caregiver? And once again, we can kind of see that this information was on, potentially included on Disclosure 6 or 6SA within governmental regulation. I know there's kind of a question whether or not caregiver or patient cards need to be included on there. As I've always said, err on the side of disclosing more. And, technically the caregiver card, you are subject to certain regulations under the state of Michigan as far as plant counts, patient numbers, possession amounts. And I think that qualifies enough there as far for purposes of this disclosure and what I think that this type of disclosure is getting at to put it on there. So it's likely that LARA already knows that. But if you do answer yes to that, then there's a plethora of questions that kind of go a lot deeper than just the surface of, are you a caregiver?
And you'll see the first couple, they start very, very simple. But then, if you're reading ahead here, you'll see some of them become a little more problematic, right? So to start, when were you registered? What was, when were you a caregiver? How many patients? Were you a patient? If you're currently having patients, they want to see your different caregiver cards. Now, if you're familiar with a caregiver card, they have your caregiver number on the front and then your patient information on the back. So that patient information is confidential. So they don't want you providing it. But, basically in order to prove you're a caregiver, you have cards and, they're reasonably asking to provide those cards, which you should have done anyway in your Section 6SA. But then we move on to where clearly the information, the juicy information is going to come out. So they want to know, what amount of compensation did you receive from the patients you're connected to, right? And how did you determine what that amount was? And, provide information about that.
Now, Travis, I had a question about that because at certain board meetings, there's a discussion as to whether caregivers can be compensated for the time and resources and energy and effort that goes into caregiving and growing and cultivating those plants for their patients. And is there any clear answer in the 2008 Medical Marijuana Act that would say, just on its own as a caregiver, can I get compensation for my patients? And is that, as far as
the answer is clearly yes. But there's a difference between, being compensated for what you're doing and then, seeking profit for what you're doing. And I think as a cannabis advocate that the law makes it clear you can be paid for your services just like any other service you provide. But the language itself of the section where the Medical Marijuana Act says you can do that does, basically say seek remuneration for your services.
Mm-hmm. So, and they have clarified that in some case law that is a permissible thing for a patient to do for their caregiver, which makes complete sense. If you're allowing somebody to grow medical marijuana to assist you with your medical use, it makes complete sense that you would pay them for their time and effort and the energy that it would cost them. And with ever some, agreement with your caregiver, you would determine that amount of compensation, if any. Some caregivers do this altruistically and, understand maybe as patients themselves, and they don't want to charge the other patients that they're growing marijuana for any money because they're doing it out of the good and kind will of their hearts. So that's also...
But we have to be fair as well. Just like my previous example, if what you're getting paid is reasonable, there's probably not going to be much of a problem. But if your getting paid is not reasonable, then there might warrant additional exploration of that, right? So me personally, I don't think there's a rule or a number about what would make sense given what your services are being. But, there's clearly some thresholds, right? Mm-hmm. If you're making millions and millions of dollars helping 5 people, with their medical marijuana needs, then there's probably going to be some hard questions you're going to have to answer. But if you're making based on the amount of time, the equipment you're using, the quality of the products you're providing, if you're making, decent money compared to another caregiver whose services aren't as robust, that seems reasonable to me. Mm-hmm. So, but let's move on because.
Well, I was just going to say, I think on the other side of it too, if you say you're charging your patient $1,000 a gram, then it just looks bad. And even if your quality of your product is that high, you're charging someone who you're helping a premium amount of money, well over 1,000 or 2,000% what it normally would be, and that also looks bad. Aside from the fact that it could look suspicious if you're really charging so much higher than what you could or should reasonably charge a patient that you're growing marijuana for.
Right. So let's look at question 7. Question 7 is, where are those plants being grown? And here's another point where LARA is connecting the dots from the different disclosures you're making. So, other parts of the application, you need to list your real estate interests. So that's not only places or homes that you own, but also things that you lease. It even could include vacation homes, timeshares, etc. If you have a real estate interest, either privately or as part of a business you own or something, you need to be listing deeds and leases and land contracts.
Easements, lots of easements.
Yeah. So basically, if you're a medical marijuana caregiver or even a patient and you're growing plants, well, you have to be growing those plants somewhere. Maybe you're growing them at your own private home, or maybe you are growing them at some other location. And if you are growing them at another location, you probably have some sort of interest in being there, whether you have the landowner's permission or you own that property yourself. That's where LARA's connecting a dot here. If you indicate that you're growing someplace and you don't have some document saying that you have the legal permission to be in there, that could be, they want to know, okay, they're not necessarily going to go look at your plants, but if you're saying you're growing at 123 Main Street and you don't have a lease or a deed or something or permission letter from the landlord saying you can grow plants at 123 Main Street, that can be problematic for them. That seems like, that doesn't pass the smell test. That seems like an issue that would warrant further investigation. Mm-hmm. Are you really doing what you're claiming you're doing? I mean, and again, if you are, then you don't have a problem. But if you aren't, those are the types of people LARA is trying to find, right?
And I think, again, and to reference the board meeting, I prepare a scouting report. I watch it, very extensively, and I noticed that they were picking up on certain trends, or at least connecting the dots. They noticed that there were some properties, and I think we had mentioned this last week or the week before that they were identified as where caregivers were growing. And this happened to be someone who owned the properties, and they connected the dots and noticed that, we didn't charge these caregivers any rent, and I think they connected the electricity bills to having been paid for to renting these out. And again, objectively, we don't know why or what that arrangement was. Maybe there were family members, maybe there was some other understanding there.
Maybe there was other electrical use in the building that would account for some of the, it depends. Every circumstance is different.
Mm-hmm. But the more unanswered questions or follow-up questions that come from that arrangement are the concern. And then it calls into question whether the truth's being told, what's the real arrangement. So the more concrete and, proof, if it's an arm's length deal and a lease agreement, that's fine. It's always matters of degree and a case by case basis with how these questions are answered and what the, truthful best way of going about it is.
Right. So let's move to the next two, which is really the kind of the purpose of this entire video. Mm-hmm. So hopefully the screen keeps working for me. So the next question is, what are you currently doing with overages? If you previously grew, what did you previously do with overages? And just to kind of wrap these two together, indicate whether you are currently or have been compensated for overages and how the amounts of that compensation was determined. And I'll leave this up on the screen for a second as Nick and I get into it, but I don't think it's ever been, something we've washed on. Unfortunately, the Medical Marijuana Act is very clear. The connection between patients and caregivers is the lawful transfer. That's where the law protects a patient and a caregiver. A patient can receive medical marijuana from his or her card-connected patient. Card-connected caregiver. A caregiver can provide marijuana to up to 5 patients they're connected to through the system. That's the Section 4 defense. Obviously, reality in Michigan is that we've had quite a few locations where dispensaries have been existing and patients have been relying on those types of businesses to go obtain product. Well, the product has to come from somewhere, and it's pretty obvious where it comes from. And as we move from that unregulated kind of early medical marijuana program in Michigan into this more controlled, closed system, standardized medical marijuana program that mirrors what most other states are doing, we have a lot of those businesses trying to transition in. We have things like Rule 19, temporary operators. We have, the requirements of caregivers to be a part of growers and processors. We have these elements in this law that, are trying to assist in that transition. But what they can't do is ignore the fact that, our laws were what they were. Yes, they required change, but you now basically have to come clean to LARA and say, well, what were you doing? And it's unclear at this time if your answers are going to be problematic or not. Mm-hmm. So just so you can see them again, they want you to clearly indicate, if you have overages and are you destroying them? Are you?
I do have to comment on the structure of the question. They don't ask if you have. They just say, what are you doing with them?
That's
which
true.
Is very interesting. And so just to kind of make a distinction, Section 4 has the plant amount count and the possession amount of 2.5 ounces per patient. There's also the Section 8 defense, mm-hmm. which allows you to have as a caregiver and grow any amount of marijuana reasonably necessary to alleviate your patient's chronic or debilitating medical condition. And I think that's where it can kind of get a little interesting with, overages. Well, if I'm in Section 8 territory, then how much is how much? And maybe there are overages, but we don't want to get too far into, that kind of discussion.
And we acknowledge, listen, I get the Medical Marijuana Act. If you actually engage in the conduct, you're going to come in and out of compliance with that act. It would be impossible to always do what you're supposed to be doing under the Medical Marijuana Act. But there's also a distinction between, people who've been just assisting 5 caregivers or less than that, growing, just because you can grow a maximum of 72 plants doesn't mean you had to. Mm-hmm. And then there's people who clearly are pushing that boundary. And there's a lot of good reasons for that, but that doesn't necessarily mean overall those good reasonings fit well with the Medical Marijuana Licensing Act. The MMFLA. Mm-hmm. So, basically, here's the other side of this question. If you're a provisioning center applicant, especially a temporary operator, you're going to see a very similar question except for where are you obtaining your product? And, if you're obtaining it from caregivers, who are those caregivers? So even if you're just a caregiver as part of a new team going for a license, in some cases, if a store you've worked with in the past has been receiving your product, they might have to disclose you for their licensing portion. So you should be aware of that. And you should ask yourself, okay, what have I actually been doing? If there were some lines I was crossing, how far over that line did I go? And I need to now be very careful and consider the consequences of that. And it's not me telling you there needs to be consequences. I wish there weren't, but you should be aware that these are questions you're either going to have to answer to keep your application moving forward, or you're going to have to ask yourself, should you answer those questions, mm-hmm. right?
Yeah, and I think, these questions kind of put certain applicants between a rock and a hard place. It's either you have to answer the questions truthfully under penalty of perjury. If you don't answer these, there's no further work on your application, and potentially you could get withdrawn.
Right.
If you do answer them, depending on your conduct in the past, you're potentially listing certain sensitive information here that, objectively could conflict with the Michigan Medical Marijuana Act. And
let's not sugarcoat that language.
Okay.
You would be admitting to potential crime if you were someone who was providing marijuana outside the scope of the Medical Marijuana Act.
Mm-hmm. And I mean, the law is objective. It doesn't have these types of, the industry was kind of inconsistent, and there were a lot of questions and clarifications that needed to happen, which happened with case law, so on and so forth. And anyone who's ever talked to me, I always use this kind of analogy with caregiver conduct. It's kind of like speeding. Everyone knows that the speed limit on freeways for most of the time is 70 miles per hour. It's posted every once in a while. Everyone knows that. There are state police, county police, local police that patrol certain areas of the highway. And at a certain point in time, they decided that, we're not going to pull over everyone who's going 70 miles an hour for whatever reason, budget constraints, local kind of policies, to be more lenient, or just not enough manpower. And as time went on, certain communities in Michigan more or less decided not to pull over those drivers who were potentially speeding. I think as, more and more licensed facilities get up and running in the framework, there are going to be more people getting pulled over. But just because certain enforcement agencies weren't pulling people over doesn't mean that conduct wasn't breaking a certain provision in the law.
And to run with your analogy here, for speeding, everyone's familiar with speed traps or areas where they are enforcing those laws a little more aggressively than other places. Well, the Medical Marijuana Act's been the same. There are certain jurisdictions, I can name drop a few: Detroit, Ann Arbor, Ypsilanti, Lansing, Flint, where the type of medical marijuana conduct that was being tolerated was at a much higher level than other parts of our state. Think about a Grand Rapids, for example, or a Holland, or the West Side, where you didn't see dispensaries because those communities weren't allowing them. And the reason they weren't allowing them is because state law really didn't have an opportunity for those businesses to pop up. And even before, when the Medical Marijuana Act was new and they were exploring different ways to see if those types of businesses could come into existence, we kept getting these court cases really limiting the Medical Marijuana Act's ability to tolerate businesses like that. And trust me, we support those types of businesses. They were important to getting us to where we are today. No one is knocking the efforts put forth by the people involved behind those and trying to continue to push marijuana and provide safe, tested, professional marijuana to patients. But, we're not here talking about what should be happening. We're talking about what is happening. And you need to understand the Medical Marijuana Facilities Licensing Act application is an invasive summary of your financial history and your criminal history and your, how you've been operating for the past 3 years, sometimes going back 7 to 10. Mm-hmm. And if you've been making money doing something, you basically need to explain where that money is coming from. That's not a cannabis-specific inquiry. If you've been running a cash-based business doing something completely unrelated to marijuana, they're going to have similar questions so that you can explain the sources of your capital, where it's coming from. Mm-hmm. But, because we're in the cannabis industry and a lot of people that have been in the cannabis industry want to continue to be in this industry, the detail level of the questions for patients and caregivers are higher.
Mm. And I think too that to kind of build off of what you're saying, it's levels of degree. If they, you're kind of providing them a picture of how much you were speeding if you did speed for the past 3 years, onward. And if they look back and see that you were speeding going 200 miles an hour the whole time, that might have a different, input into their decision than if you were going 72 or 75 only for a little bit.
But let's also be clear, too. We keep using speeding to illustrate the example. Usually when you're speeding, the penalties involved are, civil infraction with a financial penalty. If you are out of compliance with the Medical Marijuana Act, you're talking usually misdemeanors or felonies. So the level of risk there for implicating yourself in conduct like that is certainly higher. So we're getting close to the end of our allotted time, and there were a lot more we wanted to talk about this. So we're going to kind of speed through the rest of the questions you can expect to see, but I will put them up on the video so you can see them, and we'll, that way you can at least know what to be prepared for. So we'll go through those real quick, and then we're going to wrap some things up. But the next question is for patients. You can tell, if you're just a patient and not a caregiver, a lot less problematic, rounds of inquiries here. Are you a patient and you're currently growing marijuana? Well, how many plants do you have and where are you growing those plants? Again, connecting dots. If you're not growing in a place you live, but you're growing in another address, well, how are you allowed to be in there? If you don't have a lease or something, or you don't own that property, you might want to be prepared to prove you have the landlord's permission. The next question here is explaining how you might have worked for some of these businesses. So other than as a patient, have you ever been involved in any capacity with a facility, a club, association? Were you a bud trimmer basically? Were you a receptionist at a dispensary? Were you working for one of these? Maybe you didn't own anything, but if it was involved with marijuana, they want to know where you worked, where that facility was, when that facility was operating, other people, and they're basically asking you to, if you worked for one of these businesses, what was your involvement, where was it, and who were you working with, right? Which, again, for some groups might be more problematic depending on what your answers are than others. And then finally, this last answer is mostly for temporary operating facilities. But it's just, if you're claiming to be a facility that was in operation before, they want to know a little bit more information about you and how you were sourcing your marijuana. Obviously, medical marijuana is, as we said before, has to come from somewhere. So they want to know where it's coming from. Medical marijuana for any state. In fact, marijuana in general, as it's only a state, legal right now, if it's coming from outside the state, that's a big problem. So this LARA has indicated they're seeing brands and sources that factually indicate they are coming from places they shouldn't be coming from, namely businesses outside the state of Michigan. So this line of inquiry is mostly designed to give those temporary operators an opportunity to explain, where their products are coming from. So hopefully you can go back through our video if you need to look at those questions in more detail. Mm-hmm. But we wanted to basically talk about these questions and inform people that these are the types of things they can expect because, unfortunately, these questions aren't on the application. They're follow-up after you've submitted an application. And especially, for clients or for groups that put their applications in before LARA realized these were the types of questions they wanted to ask, you didn't necessarily have the opportunity to anticipate these questions and how your responses might warrant, consideration. Mm-hmm. And it's not my goal, or I don't think it's our goal, to scare caregivers away from the application process. But depending on how you personally would have to answer these questions, you should consider not only what your answers are, but how this current board would, respond to those types of questions. Mm-hmm. Clearly, they are taking certain elements of information they're finding on applications they're reviewing and focusing in on it, sometimes, wanting to see information or having problems with the information they're finding.
Mm-hmm. Yeah, and I think that it's not, there are those disqualifying criteria, felonies within 10 years, certain misdemeanors. But then those are those optional reasons why they can approve or deny your license, and a lot of that includes this information. And while it is serious and it should be really carefully considered, the data, at least we've seen from the board meetings, is that there have been certain temporary operators that have been approved. There have been questions about certain caregiver applicants that have been brought up that the board ended up as a majority voting on and approving. So again, we kind of have some data, and we don't know what goes all into that decision, but we do know that it isn't an automatic disqualifier, and we know that caregivers are answering some of these questions. But I also think that as I mentioned, they are very careful questions that must be considered. We don't, and I guess this is the legal disclaimer of the day, but none of this should be construed as legal advice from us. We're simply talking about the questions and kind of workshopping them based on the landscape of Michigan since the MMA to the MMFLA right now. I think that anyone who's a caregiver that has been being asked these questions, or this is new to you and you have some questions, I would definitely consider reaching out for some legal advice and talking to any attorney about this situation that can provide you with a little more context as to what the consequences are of answering them, obviously what the consequences are of not answering them, and then kind of making your own decision based on that information as to how you want to, as an individual, proceed within the license framework.
But I also think it's just as important because if you're an applicant, you're either going to most likely have caregivers as a part of your team or be a caregiver yourself. And before you just rush in to submit an application, you should probably think about how the caregivers involved with your project, and even the patients in some cases too, or people who've worked for these types of businesses, how are their answers going to be perceived by a board who's being hypercritical right now? And there might be some strategy about how your final group of supplemental applicants is going to look like as you move forward with these licenses. And just because you're not an owner of a license or on the original Vanguard team trying to get that license for the first time doesn't necessarily mean there's not a role for you as a caregiver, a role for you working with caregivers that could be explored in the future as the state does come to some more predictable conclusions to what they want to do with this type of information. But as Nick said, it's not black and white. It is going to be individual dependent. Caregivers who are flirting with stepping over the line are going to have a much easier go of it than caregivers who are doing conduct completely out of touch with the Medical Marijuana Act. So,
and I think it also, sorry for cutting you off there. I think it also makes a difference too. If you were engaging in that conduct, but still had the willingness to disclose that and report that income and pay the taxes,
right?
Just one or the other. One looks better than if you were doing that and then didn't. And
right.
so it's always
to go with that
levels, degrees and different levels of
right.
extremity.
Or to go with that, maybe you haven't been keeping track of things as cleanly as possible. Maybe there are some things you maybe should have declared on your taxes. You have an opportunity to work on remedying that right now. And showing that you were doing that as you went to shift into these licenses, showing that you want to be regulated and play by the rules by, okay, maybe you didn't declare income on some of your taxes. Well, go declare it now. Work with an accountant. Clean it up. Figure out, okay, what have I been doing? How much have I been being paid? What kind of consulting was I doing? Can I justify the amount I was making? If you can provide answers to that, you're going to be much better off than someone who sees those questions and ignores them or, why are most applications being denied? The state realizes there's knowingly, false information provided. They have to deny you if they learn that. Mm-hmm. So, understanding what your situation is and how you would proceed is clearly what you need to do. And that's why we wanted to provide these questions. There are other questions that warrant consideration too. But now that, LARA is starting to standardize these a bit more, we can expect most applicants to have to go through a line of inquiries like this.
Mm-hmm. Yeah. And again, I know that Travis mentioned the board is being hypercritical, and not to say that in a negative light. I think it's just, it's, again, as we've stressed, it's new to everyone. The board mm-hmm. is working on refining its processes. Each municipality, this is something that is, that they hold dear and true to them, is that, they are there to protect the public health, safety, and welfare. And it's new, to some of them, it's scary or it's just unfamiliar. And it's going to take a little bit of time for everyone in Michigan to get more accustomed to the medical marijuana idea overall. And to go along with that, they're still trying to set the bar and get the metrics for where they want the bar to be for where are we going to license these people. It allows them to look at history of regulatory noncompliance, taxes, financials, integrity, moral character, knowingly submitting false information. All this stuff and all these questions go directly to the heart of that. And as we've always said to everyone, and again, this is a case by case basis, it's not about the actual facts, it's how you answer them, and it's mm-hmm. it's a lot of that where it really comes into
right.
to light, and how fully transparent and how fully disclose your how disclosed
right.
your things are. So
exactly. So that's probably going to do it for us today. Thank you for joining us. Please let us know if you have any questions about some of the information we talked about or previous videos. We're always happy to jump in the chat and talk and try to clarify some things. Like I said at the top of the video, we have a conference we're planning on October 11th. It's going to be a full day kind of seminar about the status of medical marijuana applications and how that process is going, and also looking forward and anticipating the November recreational ballot and different things you'll want to consider for that. So we'll have more information about that soon, but it's October 11th. It's coming up pretty soon. All of our videos are always available on our YouTube channel. Visit us at cannabis-legal-group.com. We always have news and updates and blog articles about certain topics, deep diving into information. It's all there for you if you're looking for something in more detail. Thank you for joining us. So I'm Travis.
I'm Nick.
And we'll see you next week. Thanks, guys.